attacked Ziva, Ziva said, okay, look, my mark is also registered, so no infringement, sorry. Statute doesn't permit it. But Jiva was able to contend that Ziva has wrongfully got on the register because I was prior and Ziva was subsequent. Therefore, prima facie, Ziva's registration is invalid. Therefore, an injunction must follow. And it did follow successfully. You would notice, once I go a little further, is that the Bombay High Court test is a stricter test to question validity. It must be ex facie, illegal or fraudulent, or must shock the conscience of the court. But the Delhi approach has always been that if at an interlocutory stage you are able to establish that the provisions of section 9 or 11 have not been complied with, that itself will be enough to sort of succeed on the question of prima facie invalidity. So in my view, the test of Bombay High Court still appears to be a stricter test than the Delhi test. The next, so the burden of proof, as the last slide shows, on the defendant in Bombay is higher, therefore he is tilting. Now, carrying on business through virtual presence, what does this mean? Section 134 of the Trademarks Act is an exception to section 20 of the Civil Procedure Code, which enables a plaintiff to sue a defendant where the plaintiff carries on business. So a registered proprietor of a mark can sue a defendant where the plaintiff carries on business. The normal rule is that he must go to the place where defendant carries on business or where the cause of action arises. But section 34 allows you to sue at a place where the plaintiff carries on business. Whether the defendant carries on business or not is irrelevant, even if the cause of action doesn't arise in his jurisdiction. But the question for the first time which arose in Delhi was whether a plaintiff can be said to carry on business in India through its website on the internet without having any direct or indirect physical presence of business or presence in Delhi. Without having any physical presence, if he is carrying on business only through the internet, buying and selling only through the internet, can the plaintiff, particularly a foreign plaintiff, for example, select Delhi as a jurisdiction because he is carrying on business through the internet in Delhi? That was the question. The test which was applied by the Delhi High Court was, is the essential part of the business of the plaintiff carried on Delhi? Is the essential part of the business of the plaintiff being carried on in Delhi? That is the test which the Delhi court applied. The Delhi High Court said physical presence is not required. If the plaintiff is able to establish that through its website an essential part of his business is being carried on in Delhi, he will be set to carry on business in Delhi and Delhi High Court will have jurisdiction. In this case, these are the aspects which were considered by the court. the website of the plaintiff could be accessed from any part of the world, including Delhi, and customers could place purchase orders on the website itself. Plaintiff's advertisement on the website, advertisements about its goods, etc., constituted an invitation to offer. This is what the Delhi High Court reasoned. Then, when the invitation was accepted by the Delhi customer on the internet, that was considered to be an acceptance, that was considered to be an offer made by the customer in Delhi to the foreign plaintiff in America. Simultaneously, when payment was made over the internet by using a credit card, there was a simultaneous acceptance of the offer by the plaintiff, which all took place in Delhi, according to the court. I use the credit card and there is simultaneous acceptance. And delivery of the goods also, pursuant to my placing the order, also took place in Delhi. So, offer plus acceptance plus payment plus delivery, all in Delhi. Therefore, essential part of the business of the plaintiff carried on in Delhi, and therefore, a foreign plaintiff can sue, select his jurisdiction of Delhi and sue him in Delhi, even if the Indian company was located in, say, Tamil Nadu, and all his goods were only sold in Tamil Nadu. The court interestingly held as follows. It is possible for an entity to have a virtual presence in a place which is located at a distance from the place where it has a physical presence. In other words, physical presence is not required. The availability of transactions through the website at a particular place is virtually the same thing as a seller having shops in that place in the physical world. So the website is analogous to a shop. Now this is a judgment which is of tremendous use to the plaintiff, particularly to a foreign plaintiff who often does not have a physical presence in India. Even in such circumstances, the plaintiff, foreign plaintiff, can select a jurisdiction of its choice so as to most inconvenience the defendant. The third case, I will deal briefly with the Raymond case and the Bloomberg case. And here again you will see the divide between the Bombay approach and the Delhi approach. Raymond Limited, which is the renowned textile company, sued Raymond Pharmaceutical Private Limited because of the use of the corporate name Raymond Pharmaceuticals Private Limited. Raymond mark was registered for textiles and many other goods, but not for pharmaceuticals. Raymond Pharmaceuticals Private Limited only used Raymond as part of its corporate name. It never used Raymond as its trademark. It only used it as a part of its corporate name, and not in relation to its goods, as we normally say. Now, when Raymond sued Raymond Pharmaceuticals, the defendant successfully, that is Raymond Pharmaceuticals, successfully contended, okay, look, my business and Raymond Limited's business is totally different. And section 29(5) specifically allows a plaintiff to sue against the use of his mark as part of the corporate name if the plaintiff's business and the defendant's business is in the same field. So there is a specific provision saying that if the plaintiff and the defendant are in the same field of business, then use of corporate name by the defendant, only use of corporate name, even if he doesn't use it as a trademark really, will still amount to infringement. That is one aspect. The second aspect, where the Bombay High Court and the Delhi High Court approach differs, is very interesting. The plaintiff contended that even if I am not able to rely on 29(5), which is relating to use as part of corporate name, which required that there has to be similarity of goods and similarity of businesses, I am contending that Raymond is a well-known mark, is a famous mark. Therefore, his using Raymond Pharmaceuticals Limited dilutes my mark. And it still amounts to infringement, though it is in relation to different goods altogether. Under 29(4). That is the anti-dilution provision. The court said that since there is a specific provision dealing with use as corporate name, that is all-encompassing, and once you fail under 29(4)(5), you cannot rely on 29(4). That is the Bombay approach, infringement now. That was held in Raymond versus Raymond Pharmaceutical Limited. So infringement is not permissible if the defendants only use it as part of the corporate name and their areas of operation are different. There is no infringement. But interestingly, in another case, the court has held it may still amount to passing off, because 29(5) does not affect the common law rights. So even if you use Raymond, in this case it was Kalpaturu, even if Kalpaturu is used as part of a corporate name in a different area altogether, though it may not amount to infringement, it may still amount to passing off. But in Delhi, the courts have taken the view in Bloomberg versus Bloomberg that even if the area of operations is different, therefore you cannot rely on 29(5), you may still rely on 29(4), because Bloomberg is a famous mark. So in that sense, though you don't rely on 29(5), you may still rely on 29(4) on an anti-dilution provision, and and he differs with the Bombay High Court approach, the Delhi High Court approach. Then the famous Nandus versus Nandos case. Here, Nandus or Nandus, I don't know, was registered by Balkrishna Hatcheries, an Indian company, for processed food and frozen meat products. In processed food and frozen meat products in class 29. Nandos, which is the world famous restaurant, proposed to use it in respect of its restaurant services. So here the plaintiff had a registration, Balkrishna had a registration only for goods, processed and frozen meats, and Nandus wanted to use it in relation to its restaurant services. And Nandus contended that his services, that is Nando's services, are similar to my services, to my goods. Therefore it amounts to infringement. The court held that similarity or association that is referred to in section 29 can only be a similarity between goods and goods, or a similarity between services and services, and cannot be a similarity between goods on the one hand and services on the other hand. So goods cannot be said to be similar to services ever, with respect, I totally disagree with this judgment. But it appears, there are observations in the Madras High Court and the Delhi High Court decisions which seem to suggest that this is not the correct view, and similar services, goods can be sort of compared with similar services so as to constitute infringement. Thanks.
Okay. Thank you so much. It was very, very interesting. May I now give the floor to Farah Bhatti, talking about, she's not here. Now, it is up to you, Gautam, to speak about the Madrid Protocol. Thank you.
Mr. Simon, distinguished speakers on the dais, and the august gathering of the dais. Now, whenever I stand up to speak on intellectual property, I'm reminded of an incident that occurred to the famous English author Sir Oscar Wilde. Once British Customs asked him, "Sir, do you have anything to declare?" He promptly replied, "Yes, certainly, my intellect." Now, at that point of time, it might be a joke that intellect can be a property, but yesterday's joke is today's reality. It is the highest kind of property that one can have. Now, coming to my topic, Madrid Protocol, which is a tool of the Madrid system. In one word, I would like to place it that in the era of Windows, a new window opens for India. If we can take the advantage properly, it is a huge tool to get protection in multiple jurisdictions through a single window by single filing, single fees, single renewals. Now, what is the system all about? As I said, it's a tool to protect one trademark in multiple jurisdictions. It is more than 90 countries and regions by filing a single application centrally. The Madrid system is governed by two treaties, that is Madrid Agreement and Madrid Protocol. But for certain reasons and certain advantages, the protocol is gaining more ground than the agreement. It is administered by IB, International Bureau of the WIPO, that is in Geneva. Now, how to take advantage of that? Who can apply for Madrid international registration through Madrid? It must be any natural or legal person who meets the following criteria: either a national of, or a domicile of, or has a real and effective industrial and commercial establishment in a state that is either directly party to the protocol or a member of an organization that is party to the protocol. Now, can you directly go and file a Madrid application? No. It has to be based on a prior national or regional registration called basic registration, or a prior national or regional application for registration called basic application. This is another advantage of the Madrid Protocol, because under the agreement it was only registration upon which you can base your international application, but under the protocol you can even base your application under a pending application, or on several prior registrations or applications, provided together they cover the goods and services listed in the international application, and the basic application or registration being owned by the same party in the same jurisdiction. That's very important. Now, the trademark office of the jurisdiction that holds the basic registration and or application is called Office of Origin. You cannot directly file an international application to IB. It has to be routed through the Office of Origin. And once, while filing the international application, one of the important jobs is to designate contracting parties. As I said, you can cover multiple jurisdictions through a single application. Those jurisdictions you have to pinpoint and you have to designate. Now, before transmitting your application to IB, what the Office of Origin does is basically certifies regarding the date of receipt, whether the applicant in the international application is same in the basic application or registration, whether the mark applied for is identical along with the basic application or registration. Basically, it's tallying the international application with the basic application or registration regarding whether they are similar in all respects. I'll skip up some slides because of the paucity of time. Now, once it is forwarded to IB, what IB does, IB examines the application, but IB doesn't enter into merit. There is no substantive examination at the international stage. It is just formality checks, like again tallying, defect regarding application applicant's entitlement to file, supplying of clear reproduction of the mark, because that's very important, whether there is any shortfall in fees, whether there is correctness in classification, classifying the goods, whether there is any vague terms, in that case objection comes in. Upon doing all these things, once the International Bureau IB is satisfied, it grants international registration. That's a huge advantage of the system. Now, if we compare it with PCT system in patents, that doesn't grant any international patent. That can't be, because it's subject to examination by each state. But here, it's a little ahead. It grants international registration. Now, there might be a question regarding respecting the sovereignty of the contracting states or designated parties. How can you impose a registration upon all contracting parties without checking with their laws and all? I'll come to that aspect very shortly. Upon registration, IB notifies the offices of the designated countries, informs the office of origin, publishes the international registration in WIPO Gazette. And here also, earlier under the agreement, it was only Spanish or French. It might be French. Yeah, French. Now, under the protocol, you have choice of English, French, and Spanish. That is another advantage. It gives you better leverage. Now, what is the date of your international registration? Normally, the date on which the Office of Origin receives the international application, provided the IB receives this within 2 months of the date of receipt by the Office of Origin. So, I am in a very much advantageous position. I filed my application online in Indian Trademark Registry, my Office of Origin, and that is the date of my international registration. See the strength of priority that I am getting. Otherwise, if it is more than 2 months before the IB gets it from the Office of Origin, then the actual date when IB receives the application. Now, regarding key irregularities, I'll again skip because I have to be on time. I have myself reminded here, so it's my duty. So let us keep all these key regularities. Now, protection of international registration. What it is, from the date of international registration, each DCP, designated contracting party, must afford the mark the same protection as if it has been filed directly with the office of that CP, provided there is no refusal of protection, which is called right of refusal. I'll come to that later on, is notified to the IB within the prescribed limit, or in case of such refusals, that is subsequently withdrawn. A provisional refusal need not be final within the prescribed time limit that I am stating about. It is sufficient that the office of the CP notifies the provisional refusal within the set time that yes, I intend to oppose or object, either ex officio, or there might be opposition from my nationals at some point of time beyond that prescribed time. Now, subsequent designation, again I'll skip that. There are more important issues like dependence, central attack, and transformation. I think this is the most important part of the con side of Madrid system that we must be quite aware of. For the first 5 years of registration of the international registration, the validity of international registration dependent on the fate of the basic application or registration. That's very, very important. Now, that is a great tool in the hands of the original adopter and registrant of the mark, original proprietor, to go against deceptively similar mark. Like if a deceptively similar mark is registered internationally designating say 50 countries, it's not required for the original adopter or proprietor to run from pillar to post in 50 jurisdictions to cancel that. If it is within 5 years of international registration, it is enough if the original proprietor attacks the basic application or registration in the Office of Origin and can cancel that. So the international registration ceases to be of any effect in any jurisdiction if or to the extent that the basic application or basic registration falls. What might be the grounds of attacking those basic application or registration? Is On what grounds? On the following reasons: that it is withdrawn or refused, or the basic registration is cancelled, rectified, or the basic registration lapses for non-renewal. Whether the basic application or registration is lost voluntarily or through a trademark office decision or through a court order, really not relevant in this case. The ground or the circumstances leading to the refusal or cancellation being unique to a particular law of jurisdiction, again, is irrelevant. Once the basic application or registration falls, your international registration designating all those countries falls like a house of cards. Now, procedure on seizing of effect of the basic application of registration. Duty of the Office of Origin is to notify the IB as it is if an action is commenced during the 5-year period dependency that could result in either the basic application being refused or the basic registration being cancelled, even after the expiry of the period. It is important that the action is initiated within the 5 years period. Even if 5-year period is over after the action is initiated and it takes longer time to be decided, not an issue. Notification to IB of the outcome of such application. Notification to IB regarding cessation of effect of that application, means that basic application or registration. Request to IB to cancel international registration to the extent applicable. Now, on the part of the IB need to record these notifications, complying with the request of the Office of Origin to cancel, publication of cancellations and notifications of pending applications in the WIPO Gazette so that everybody can come to know, sending copies of notifications, etc. Now, this system of dependence for the first 5 years and this option of attacking the basic application and destroying the international registration is called central attack. After 5 years, international registration sort of comes of age and becomes independent of the basic application or registration. So there is a good balancing between good marks, deceptively similar marks, and finally marks getting matured. Once after the initial 5 years is become independent of the basic application or registration, then the validity of the international registration depends on the domestic trademark law of each CPs to which it has been extended. Cancellation of the international mark in one of those jurisdictions does not automatically lead to its cancellation in other jurisdiction after 5 years from the date of international application. That's very, very vital. Now, say for instance, one proprietor loses his international registration due to the lapse of the basic registration or application. Is that the end of the road, or there is still rays of hope? Yes, that provision has also been thought of. You can, if the international registration is cancelled by IB, request of the Office of Origin, on the request of the Office of Origin obviously, the same may be transformed into a series of national or regional trademark application without a loss of priority. So your international registration goes, but you still have hope in all DCP countries, provided the application for transformation is filed within the office of the DCPs within 3 months from the date of cancellation of your international registration. Can only be made for those goods and services naturally regard to international registration. Transformation application is governed entirely by the domestic law obviously, but transformation is not available if the international registration is cancelled by the IB at the request of the holder. I being the holder, if I request IB to cancel my registration, then suddenly I change my mind and I transform it to national application. That's not allowed. Now, the right of refusal that I was referring to, this is the tool to respect the sovereignty of each designated countries. Each DCP has right to refuse protection of the international registration in its territory. Grounds of such refusal must be based on the Paris Convention conditions that would otherwise apply